Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at an excellent book which has come to us from Wildy, Simmonds and Hill Publishing. This is in their series of practitioner guides. There are a whole series of them that I am reviewing over a period of time. This one appeared a little while ago. It's called A Practitioner's Guide to Probate Disputes. It's been written by Nasreen Pearce. Elizabeth and I talked about this book and the series of books which we are reviewing, and we gave it a title for our book review of An Important Short Statement for All Involved in Probate Matters. And that in fact is the case, because one of the things I like about these books is the fact that unrepresented parties will find them helpful as well as practitioners. And I think that's an important factor to bear in mind when we have such a large number of litigants in person. They come to see me, and quite often they've got no money to actually spend on matters, but at least they will get some advice, and I can point them in the right direction if they're not going to be able to use my services. I've certainly done that with this particular book, because I had a probate case the other day and they went away and got the book. There's the spine, the front page and the spine, and then there's the back. This book is actually very helpful. It has to be read in conjunction, of course, with the procedural rules and everything else, but it is in fact an important book and very much part of the style of Wildy, Simmonds and Hill. There's the index at the back and its page numbering. There's a relatively short index. It's not a big index. You can see it starts there. Then you've got the main work. These some annexes at the back, and then you've got the main work itself. You can see there is paragraph numbering, so you can find things quite quickly. The index is actually on page numbering, not paragraph numbering, and you do have the actual reference numbering there, the paragraph numbering itself for each of the chapters, so chapter 14, 14.1 and so on. Now at the front of the book you've got A Practitioner's Guide to Probate Disputes. There's the front page. Then you've got basic information about Wildy's. Then you've got the contents section, which runs through, shows you a lot of information there. There's a lot of detail as we run through the various contents. The total number of chapters, 15, ending up with statutory wills. Then you've got a series of appendices, and they're actually A, B and C, rather than 1, 2 and 3. Then you've got the table of cases, of which there are quite a few, and statutes, of course. And then guess what? Statutory instruments, yes. And then after that, there's some conventions listed too. And then after that, we get into the introduction. And it starts off, disputes over wills and inheritance have been soaring since 2006. Again, you can see on the basis of the figures given, they were 64% higher than in 2006. And this was written, the book actually is copyrighted for 2016, and I'm recording this at the beginning of 2017. What do we say about the book? Because as I've said, this is one of the number of books. There are numbers of other ones, like there's A Practitioner's Guide to Mental Health. There's one on wills as well, which I'm looking at. But this one is on probate disputes, so let's deal with that one today. Well, most unfortunately for many people, disputes over wills and other testamentary dispositions have been on the increase since 2006, as I've indicated. So when this new title, A Practitioner's Guide to Probate Disputes, arrived on our desks, and actually now on the market, it's provided an invaluable guide, I suggest, to the relevant legal framework and the basis upon which a will and other testamentary provisions might be challenged by interested parties. I did use this recently when I had a particularly difficult question. The parties didn't have much money and they were very concerned about certain aspects of a disposition. And this book, as much as anything else, helped them realise what they might have to do if they were going to make a challenge. And I did think that gave them some reality on what is a very emotive and difficult subject for many families. Now, we feel then that Wildy, Simmonds and Hill are to be congratulated for the development of what is an excellent and helpful series of books, which they call practitioner guides, and this is just one of them. They're great for advisors, for practitioners, and of course unrepresented parties alike. And the latest title to reach us from Legal Stable is Nasreen Pearce's A Practitioner's Guide to Probate Disputes, which gives us a comprehensive and accessible text on the complex but fascinating area of probate, which is certainly for the specialist. Not an area that I do very much in myself, but it does crop up, and it can sometimes be part of a whole range of other things within my legal practice, and certainly that, of course, of a solicitor. Now, Pearce covers matters of everyday concern to lawyers, and does very well indeed. It covers also information for advisors and other professionals in what is a clear and easy to read format, a hallmark, in fact, of the Wildy publications, and I thank them very much for that. The book covers issues relating to the form and content of a will and its execution, including testamentary capacity, knowledge and approval. And with the increase in the ageing population, issues such as undue influence, fraud and forgery are recurrent grounds for dispute, as I'm sure you will see in the newspapers. And can I also say, of course, that it is important for people to bear in mind they should make a will, and there's still quite inadequate information given by the government about the fact that so many people don't make wills when they should do. They should think seriously about what they're doing, because once they're gone, other people have got to pick up the mess, and it costs a lot of money, which is sometimes quite unnecessary if you've just had a little bit of thought beforehand. And that's one of the reasons why I think these books will be of help, because it's the people who are left who have to deal with the squabbling, the fighting relatives and all the other problems, which causes a lot of heartache, which can quite often be can be dealt with. Sometimes it's done deliberately. That's one of the problems, of course. Now, the book also features the more usual lifetime testamentary dispositions and the claims and challenges that can be made in relation to them. And that's where really we come in as lawyers, because that's when they come to see us as clients. It's the people who might be the beneficiaries of it all. It also includes, of course, a very useful overview of the claims that can be made under the Inheritance Provision for Family Independence Act 1975, which again a lot of people don't know much about. What the guide does do is it gives excellent and succinct guidance as to best practice and sets out examples from case law to illustrate the legal requirements and the problems which can arise from poor drafting and a failure to investigate sufficiently all the circumstances relating to the testator or testatrix. Now, you can understand again that this is where some of the problems are. Now, clearly, as I've said before, wills are an important area of generally a solicitor's practice. They don't come to us as counsel that often, but certainly we have to know a bit about them, even if our general practice is more on the common law side, such as mine. But it is useful to know what's going on, because, as I've indicated before, a large number of people still do not make a will, and we don't know what to do, and that causes a headache for a lot of people. Let me conclude by saying a commentary on disputes which may arise over the burial of the body and the relevance of rights under the European Convention for the Protection of Human Rights and Fundamental Freedoms are also well covered here. That again, this is a very delicate area. You've got to be very careful with the advice that you give, because people do get very emotional, and it's understandable, because their nearest and dearest have died, and then the fighting starts, and you have to just see it sometimes to believe it. And I think this is why Nasreen Pearce has given us such an excellent statement of where we are today on this subject. I'd like to thank all involved. The publication date for the book is 2016, and I'm recording it in 2017. Here's the front of the book again. Now, the author, she's actually the general editor of the Emergency Remedies in the Family Courts book and contributor to Family Court Practice. And she has been formerly a district judge in what was then known as the Principal Registry of the Family Division. In fact, I think I did appear before her on one occasion quite some time ago. Of course, now it's called the Central Family Court now, of course. Now, this is on burial, and you can see again a very detailed amount of information, appropriate consent, nominated representatives. And then you've got all sorts of other controversial areas. This one is a very big one. Human Fertilisation and Embryology Act 2008. Posthumous use of sperm. Again, you see all these issues, really personal, but very well dealt with here by Pearce. I'd like to thank her and everybody concerned. You make our lives a lot easier by publishing these books. I think you make the lives of ordinary unrepresented litigants a lot better as well. So thank you. It's meant as well. Thank you very much. Bye-bye.